Good afternoon. This hearing of the Subcommittee on Intellectual Property, Competition, and the Internet of the Committee on the Judiciary will come to order, and I will begin with my opening statement. Today, the Subcommittee will consider the issue of patent design protection to determine whether amendments should be made to the law to limit protection for component parts of automobiles. Chapter 16 of the Patent Act allows an inventor to earn a design patent for any new, original, and ornamental design for an article of manufacture. However, the chief limitation on the patentability of designs is that they must be primarily ornamental in character. If the design is dictated by the performance of the article, then it is judged primarily functional and ineligible for design patent protection. Combined with the costs of patenting, this explains why some inventors, including automobile companies, have traditionally filed for relatively few design patents. However, auto manufacturers assert that automotive suppliers lose upwards of $12 billion annually to counterfeit products, and at least one prominent car company invests $100 million or more in the design of each new car line. It is understandable that car manufacturers want to reap a return on their investments, and they have attempted this in a variety of ways. For one, in the past, manufacturers have argued for Congress to amend the Patent Act or the Copyright Design Statute to provide greater protection for designs. In addition, there has been a recent increase in the number of applications for design patents for individual parts of vehicles. This latter approach has raised the ire of those who work in the automotive aftermarket parts industry. Independent garage owners fear they will go out of business if the Patent Act is used by the auto manufacturers to obtain design patent protection for more and more individual parts rather than for the design of the car as a whole. Insurers worry that the cost of insuring vehicles will increase for consumers if manufacturers aggressively assert these rights because there will be less competition for replacement parts. The aftermarket parts industry argues that we can't afford to maintain the legislative status quo on patent designs. It argues the auto manufacturers are filing more and more design patents under current law, meaning the independent garages could lose a war of attrition. Representative Issa has introduced H.R. 3889, better known as the Parts Act. While the bill doesn't prevent automakers from patenting designs on replacement parts, it greatly reduces the time period during which they may sue competitors for patent infringement from 14 years to 30 months. Today, the Subcommittee will weigh these competing interests and the consequences of establishing the precedent of creating an exemption to design patent law. I remain open-minded on this issue and look forward to the testimony that we will receive. And it's now my pleasure to recognize the ranking member, the gentleman from North Carolina, Mr. Watt.
Thank you, Mr. Chairman. And I managed to mess up my microphone here. Either it's an ornament or a design or a functional issue, but regardless, I have to hold it up because I broke it. So I see how he was such an efficient automobile thief.
You know, from anyone else, I might think you were disparaging the member.
That's an inside joke, y'all. Well, I thank the chairman for holding the hearing. Today marks at least the fourth consecutive Congress that we've considered the scope of design protection under our patent laws. Design patents protect the new, unique, and ornamental designs of industrial and consumer products. Design patents differ from utility patents. While utility patents provide exclusive rights over new and useful inventions, design patents provide a fundamentally different protection. In layman's terms, design patents protect the style and look of consumer products. Like all patents, they reward creativity by conferring upon the creator the exclusive right to market or otherwise control commercialization of his or her design for a 14-year period. This reward allows the creator to achieve a return on his or her investment and incentivizes further design innovation. The Department of Justice and the Federal Trade Commission have noted that intellectual property and antitrust laws are, quote, complementary bodies of law that work together to bring innovation to consumers, close quote. The exclusive rights granted to intellectual property holders are not presumed by the enforcement agencies to create monopolies because consumers may have alternatives or other substitutes in the market. The Parts Act, the subject of today's hearing, in effect limits the automaker's exclusive right to their design to at most 30 months, depending upon when the 30-month clock begins, perhaps even less time to enjoy the exclusivity of a design patent. The proponents and opponents of the proposed modifications to the protections afforded to automobile aftermarket parts under current law have fundamentally different views of the market dynamics in the replacement parts industries. Supporters, and I'm sure we'll hear from Mr. Issa and Ms. Lofgren shortly, so they'll correct me if I'm misinterpreting what they are saying. Supporters of the bill tend to believe that automobile manufacturers' ability to assert their design patent rights in the aftermarket may establish a monopoly in that secondary market. Under this view, the original equipment manufacturer may corner the secondary market for the 14-year life of the patent by excluding all others, exacting high licensing fees, and providing limited choices to the consumer. It is estimated that consumers keep their cars between 9 and 11 years, so the 14-year patent term engulfs the entire period during which there would be any demand for replacement parts. Most supporters would have automobile manufacturers recoup their investment in the primary market when they first sell their vehicles, leaving the secondary market more competitive. The opponents, on the other hand, argue that they invest massive sums of money into research and development and are entitled to the rewards that the patent system provides. Especially in light of advancements in technology that now allow and facilitate immediate copying of patented designs and reproduction at lower cost, often outside the United States, automobile manufacturers maintain that these free riders, as they call them, will retard innovation while providing consumers with substandard quality, substandard parts. The equities involved on both sides of this issue are seemingly compelling, yet necessarily self-interested. I think what's missing from this debate is input from the government, both from a domestic and international perspective. Recently, in February of this year, the Department of Justice announced that it had uncovered international price fixings in the aftermarket industry for auto lights, which could be covered by a design patent. The indictments and guilty pleas give rise to some speculation whether consumers are victims of anti-competitive practices within the aftermarket industry generally, and whether the alleged cost savings that would result from opening the market to non-original equipment manufacturers' parts will ever reach the consumer. I'm also mindful of ongoing efforts to enact legislation to implement the Patent Law Treaty and the Geneva Act of the Hague Agreement regarding design patents. Both were signed during the Clinton administration and ratified during the Bush administration. The proposed Hague Agreement Implementation Act makes two substantive changes in United States design patent law, including extending the patent term for designs from 14 to 15 years after the grant. Director Capos is on record urging the Congress to move quickly to implement these treaties. Therefore, it concerns me that this bill may take us in the opposite direction, limiting rather than strengthening the design protections of a U.S. industry. So while I come to this issue with an open mind, I believe that in addition to hearing from the affected stakeholders, it would be useful at some point to hear the government officials who deal with these issues in depth on an ongoing basis. And with that, Mr. Chairman, I yield back. I haven't taken a position one way or another, but that's what hearings are for.
I thank the gentleman in part to allow the gentleman to defend his reputation and more importantly to allow the gentleman who is the author of the legislation that is the subject of the hearing. I will recognize Mr. Issa for an opening statement for 5 minutes, and then after that I will recognize the gentlewoman from California, Ms. Lofgren, for an opening statement, and then we'll ask that all other opening statements be made a part of the record. So without further ado, the gentleman from California is recognized for 5 minutes.
Thank you, Mr. Chairman. As in the Constitution, to promote the progress of science and useful arts by securing for a limited times to authors and inventors the exclusive right to their respective writings and discoveries. I've read that so many times before I came to Congress while I was inventing, while I was patenting both utility patents and design patents. And I, like most people who have design patents, knew that, in fact, my design patents were ornamental. They were limited, that anyone could take a box that contained one of my security products and take off a few ornamental lines that were put on that represented both a patentable item and perhaps even a trade dress in time, but they could produce the same box. Just wouldn't be the same, but the screws would line up, nuts and bolts would match, a PC board could fit exactly the way it was. In other words, in form, fit, and function, they could totally produce a replacement part. And in some cases, people did. That's what we're talking about here today. We're talking about a recognition that first, as my colleague so aptly said as he was stating both sides of the issue, and I appreciate that, from our side, this is narrow. This is limited. It relates only to the outside of an automobile. It is necessitated only by what appears to be, in my opinion, an expansion beyond the intent of these ornamental patents to try to create effectively a 14-year utility patent on the entire automobile. Now, that's not new. The auto companies have formally tried to do that in the past. And I am a complete supporter that a part which is confusingly similar, a part that bears the trade name of the manufacturer, a part that would imply a given level of quality, predictability, or originalness, should in fact not be what we allow the aftermarket to produce. But when you consider the balance the Constitution intended, which included the, if you will, a long-established first sale concept, when I buy an automobile and then somebody bangs it up in the parking lot, I own that fender. I can repair that fender to an inferior level and nobody has a gripe. Why is it I can't buy a form, fit, and function identical part and buy it on a competitive market? The answer is sometimes you can, sometimes you can't. It depends on who's suing whom, who has gone to the ITC to enforce in a way that was not enforced for the first 100 years of the auto company this replacement parts right. That's the reason that bumpers, fenders, side mirrors, and door panels are in fact the subject of this legislation. Now, I will tell you, Mr. Chairman, the aftermarket parts manufacturers would like this to be shorter or flat, not at all. We tried to balance that, and there's no magic number. We found a number that seemed to allow the auto companies a launch period. And by the way, this would be a launch period in which if every model year they changed their fender, they would enjoy yet a new exclusive period. But we tried to have it short enough that in a relatively short period of time, as accidents happen, collisions, rust out and other damage, that they'd be able to buy a replacement part on a competitive market. Even if they couldn't buy one in a competitive market in some cases, the auto companies would tend to price their product based on a hypothetical competitive market. We believe that that limits the antitrust characteristic of parts pricing. Additionally, a healthy aftermarket means that when you get to end of life, when that 10-year period is over and the patent is still in effect, but the auto company, in the case of a small production or let's say a Saturn, no longer wants to produce those products or they're no longer available, there's a healthy aftermarket to provide that. People in Europe already enjoy some of these considerations, and for good reason. The consumer has a balance, and one of those balances is a reasonable expectation that a competitive market exists. A highly competitive market exists for the automobile, but without legislation like this, over time, in the ITC particularly, I believe that there will be an erosion of the competitive market and the availability of alternatives when that car is hit in the parking lot or hit on the highway. And so, Mr. Chairman, I appreciate the unusual opportunity to be able to introduce the bill in an opening statement. I look forward to working with people on both sides of the aisle, such as Congresswoman Lofgren and others, to ensure that we make sure that this is limited, narrow, and dealing only with the likely parts that get hurt on an automobile in everyday wear and tear, in which we'd much rather have a competitive replacement part available than have a consumer unable to fix that part properly and yet unable to afford a replacement part. I thank the Chairman and yield back.
I thank the gentleman. The gentlewoman from California, Ms. Lofgren, is recognized for an opening statement.
Thank you, Mr. Chairman, and I'm happy to be a co-sponsor of this bill with my friend Congressman Issa. In a previous Congress, I had a bill that took a slightly different approach. Basically, that approach protected the design from being copied by competing car companies, but also allowed for the independent production of parts when they were used solely as replacement repair parts. And as I think Mr. Issa has noted, that bill, although I thought a good approach, was not successful, did not become a law. It's worth noting that several European countries and Australia have actually enacted a repair clause provision in their laws. And I think we can take a look at what's happening there and see that there's real benefit to consumers, and I don't think real damage to automobile manufacturers, which none of us want to do. This bill that Congressman Issa and I are promoting is a different approach. It limits the protection period to allow for competition when it comes to the aftermarket scene. And why would we do this? Well, the Consumer Federation of America, the Center for Auto Safety, the Consumers Union, and the Policy and Advocacy arm of Consumer Reports are all in favor of this bill. And I think the reason why is that competition will lower costs for consumers. Now, that's important in a time when the economy is tough, but it's also important in some other ways. Right now, the elimination of competition from independent brand crash repair parts is estimated to cost automobile owners about $1 billion a year. That's a lot of money. Because of the high costs, there are individuals who actually don't do the kind of repairs that they ought to do, and that increases the safety risk to motorists. I agree with Mr. Issa that the time frame put in the bill was our best guess. You could argue for more, you could argue for less, but I think that this is calculated to provide for some relief for consumers when it comes to repair of automobiles while protecting completely the design of when we have the sale of automobiles. That is part of the genius of the American auto industry. I will not go on at great length, Mr. Chairman. I am appreciative that we are having this hearing, and I'm hopeful that we can actually move this bill, because I think it will help promote safety, it will certainly promote competition, and it will also save consumers a great deal of money while preserving the patent protection that auto manufacturers deserve for their design when they sell automobiles. And with that, Mr. Chairman, I would yield back.
I thank the gentlewoman, and without objection, other members' opening statements will be made a part of the record. We have a distinguished panel of witnesses today, and as is the custom of this subcommittee, before we begin, I'd like to swear in the witnesses. If you all would please stand. Do you and each of you swear that the testimony that you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you, and please be seated. Each of the witnesses' written statements will be made a part of the record in its entirety, and I ask each witness to summarize their testimony in 5 minutes or less. To help you stay within that time, there is a timing light on your table. When the light switches from green to yellow, you will have 1 minute to conclude your testimony. When the light turns red, it signals that the witness's 5 minutes have expired. Our first witness is a constituent and friend of mine, Mr. Neil Menifee, President and CEO of Rockingham Group Insurance Companies in Harrisonburg, Virginia. He will be testifying on behalf of the National Association of Mutual Insurance Companies and the Quality Parts Coalition. Prior to joining Rockingham, Mr. Menifee spent 15 years with Exxon Company USA in their marketing and corporate planning departments. He also serves on a number of boards for various business, civic, and charitable organizations. He received a B.S. in electrical engineering and with distinction from Virginia Tech, and his MBA from the University of Pittsburgh. Our next witness is Kelly Burris, shareholder of the Ann Arbor law firm Brinks, Hoffer, Gilson, and Leone. She chairs the Brinks Green Technology Practice Group and focuses on the preparation and prosecution of U.S. and foreign patent applications in the mechanical, material science, and electrical arts. Before practicing law, Ms. Burris spent more than 11 years in the aerospace industry with McDonnell Douglas and Boeing. A patent holder in the area of fiber optics, she has taught IP law and published widely in the field. Ms. Burris received her B.S. in Aeronautical Engineering from Western Michigan University, her M.S. in Materials Science and Engineering from Washington University, and her J.D. from St. Louis University. Our final witness is Jack Gillis, Director of Public Affairs with the Consumer Federation of America, the nation's largest consumer advocacy organization. This is the third time he has testified before us on the subject of automotive design patents. Mr. Gillis is the author, co-author, and editor of more than 60 books, including The Car Book, The Car Repair Book, and The Armchair Mechanic. In addition, he has served as a contributing consumer correspondent for The Today Show. Mr. Gillis received his B.A. in English from the University of Notre Dame and his MBA in Marketing and Consumer Behavior from the George Washington University. We want to welcome you all, and we'll begin, and a special welcome to Mr. Menifee. You may want to turn that microphone on and keep it close.
Got a green light. Thank you. Good afternoon, Chairman Goodlatte, Ranking Member Watt, and other esteemed subcommittee members. I am Neil Menifee, the President and CEO of the Rockingham Group of Insurance Companies, whose home office is in Harrisonburg, Virginia. The group currently underwrites and markets property and casualty insurance products, including auto in Virginia and Pennsylvania. We have annual revenues in excess of $40 million. On behalf of the National Association of Mutual Insurance Companies, the Property Casualty Insurers Association of America, and the Quality Parts Coalition, I'd like to thank the subcommittee for its attention to this very important issue. To begin, I would start by asking you to consider whether you or a family member has ever been in an auto accident and had to repair your car. Sorry to hear that if that is the case, but whether you knew it or not, you benefited from competition in the collision repair parts marketplace, competition that has existed for decades between car companies and alternative suppliers of such parts. To be clear, we are talking about collision repair parts, which are the cosmetic exterior parts of an automobile, such as fenders, quarter panels, bumper covers, and grills. Generally speaking, these are not structural or safety-related parts. Although the car companies have already captured 2/3 of the market for collision repair parts, the competition that alternative suppliers provide is still very important to consumers. Alternatively supplied collision repair parts typically are 26 to 50% less expensive than the car company parts. But even if a more expensive car company part is used, the mere existence of competition puts downward pressure on car company prices. The estimated total benefit to consumers from the availability of competitive alternatives is upwards of $2.4 billion per year. It's a great example of the free market at work for the benefit of consumers. Unfortunately, some car companies appear to want to disrupt this well-functioning market and expand their already dominant share. Beginning around 2003, they began obtaining 14-year design patents, not just on the overall design, but also on their individual collision repair parts, and then enforcing those patents against alternative suppliers. This is a significant departure from the car company's past behavior. I would point out that the purpose of such collision parts is to restore the vehicle's original pre-accident appearance. Naturally, that is what consumers demand, and it's what insurance policies provide for. State insurance laws require that alternatively supplied collision repair parts be of like kind and quality in form, fit, and finish to car company parts. Today, alternative suppliers are in the untenable position of complying with state law and meeting consumer demand while simultaneously facing allegations of design patent infringement by the car companies. These patents are simply being used to eliminate competition and facilitate a monopoly on cosmetic replacement parts to the detriment of consumers. Ultimately, the impact of such a monopoly would fall directly on consumers, first in the form of higher insurance premiums, and secondly on consumers that pay for their own repairs out of pocket. Moreover, they might choose to forego repairs altogether, leading to more rapid deterioration and depreciation of their vehicles. Higher repair costs also mean that there is an increased likelihood of a vehicle being declared a total loss, compelling consumers to replace it, pay off a loan that may exceed its value, and seek financing for the purchase of replacement. In tough economic times like today, these kinds of added costs hurt consumers that much more, especially as autos age and depreciate. The Parts Act carefully balances the car company's intellectual property rights with the need to protect consumers by preserving competition. It would change from 14 to 2.5 years the monopoly period during which car companies could block competitors from selling alternative collision repair parts. We recognize that the overall design of a car plays a significant role in consumers' choice when buying a new car, and in the very competitive for new auto sales, car companies invest a lot in the overall design of a vehicle, that unique owning and driving experience that we all see advertised on television. The Parts Act would not deter car companies from obtaining and enforcing design patents on their collision parts against other car companies. Therefore, the Parts Act does nothing to change the incentive of the car companies to innovate as they continue to design their cars to compete against each other. We respect the investment made by car companies in intellectual property, but when a consumer buys a car for $35,000 in the showroom, puts the title in his pocket, and drives it off the lot, it is his property, and he has compensated the car company for the manufacture and for the overall design of the car. American consumers should not be surprised and forced to pay a monopoly price on a collision part whenever it has been damaged in an unexpected accident and needs repair. The Parts Act addresses the problem in a properly balanced manner that is similar to how Europe and Australia have confronted identical concerns regarding the preservation and competition of things like collision repair parts. The cost of car ownership is already significant, and Americans are increasingly dollar conscious in these tough economic times. The Parts Act does not mandate the use of alternative collision repair parts, nor does it have government facilitating new entry into the marketplace. Rather, the legislation would simply preserve the traditional competition in the sale of repair parts. That's what consumers deserve. Again, thank you for the opportunity to speak here today, and I look forward to answering any questions that you may have.
Thank you, Mr. Menefee. Ms. Burris, welcome.
Thank you very much, Chairman Goodlatte, Ranking Member Watt. Roger. Okay, thank you. Chairman Goodlatte, Ranking Member Watt, and distinguished members of the subcommittee, thank you for the opportunity to be here today. It really is my pleasure, and it feels like an honor. I'm here today in opposition to the bill from a very high level because I'm afraid that this type of legislation could set a very dangerous precedent and put us on a slippery slope. If we carve out an exception for component parts for motor vehicles, it's not just automotive, and I'll get to that. If we carve out this exception, who will be next? What industry will come to you next alleging that the parts are too expensive, my computer's too expensive, and asking for their exception to infringement as well? So that's my very high-level legal concern, as is many of the people in the room today. Secondly, and I think more importantly, as a design engineer myself, I think legislation of this nature really does stifle the innovation process. The patent system is there, as Mr. Issa, you have recognized, and Ranking Member Watt, you've recognized, to provide an incentive to us to be creative and to be innovative. That's the quid pro quo. As Abraham Lincoln put it, it's the fuel of interest that feeds the fire of ingenuity. When you remove that incentive, how can we expect the creativity and the innovation to continue? Along the lines of that innovation and creativity, if we look at some of the facts, we have in the United States, there are 21 design centers, often called studios, where just the outside of the car is being designed. There are those design studios are in the states of California, actually many in California. There are studios in Ohio, and there are studios in Michigan as well. These studios, in my written testimony, we had 30,000 jobs, but some recent numbers just came in from GM. There are over 40,000 white-collar, good-paying white-collar jobs with these automotive designers, industrial designers, working on just the appearance of the car. So I think legislation of this nature has a tendency to devalue what it is they're doing, and especially on the heels of the American Invents Act. It was just put into law less than a year ago to help promote innovation in our country. To have legislation of this nature come on the heels of the AIA, I think is going in the opposite direction. I'd also like to mention that you really can't look at design patents in a vacuum or in a bubble. As Mr. Issa, you've recognized, there is also trademark or trade dress protection in product configurations, as long as the consumer can associate that look and feel with the source of the goods. There's also utility patent protection on these parts as well, oftentimes in how they are fastened to the underbody. So in order for this bill to really work, you're going to have to look at possibly making changes to the Lanham Act and also utility patent infringement. Now, turning to the language of the bill itself, it doesn't say automobiles. It says motor vehicles. Motor vehicles are defined under Title 49 as any vehicle that is driven or drawn by mechanical power manufactured for use on our streets, roads, and highways. So that means it's not just automobiles, it's motorcycles, it's scooters, it's mopeds, it's farming equipment, it's tractors, it's trailers. Looking at motorcycles alone, Harley-Davidson owns 151 design patents on the components of their motorcycles. I don't know about you guys, but I wouldn't want the biker community coming after me on this one. So, and even there's a, are we good, John? There's a gentleman here from Caterpillar that's here for the same reason, because they have new vehicles that they're protecting with design patents that they feel threatened by this legislation. The 30-month period that's in the legislation as well is not 30 months from the issue date of the patent. It's 30 months from the date of the offer for sale. You never have a design patent the day you offer it for sale. The pendency of design patents at the patent office is over 1 year. So at best, you're talking about maybe a 1-year term for design patent holders. And let's see, and I'm running out of time, but I'd also like to say that this bill is retroactive. So if you had a design patent 5 years ago, 10 years ago, guess what? It's done. It's gone. You don't have it anymore. So it reaches back. And I also think there are alternatives for consumers. There are originally equipment manufactured parts that have been refurbished that are available. There are parts that that don't look exactly the same but are interchangeable, and these parts can be repaired, and I look forward to that discussion here today. Thank you for the time.
Thank you, Ms. Burris. Mr. Gillis, welcome.
Chairman Goodlatte, Ranking Member Watt, members of the committee.
You have the same affliction. Turn that microphone on.
Thank you very much for the opportunity. I'm here today, in addition to being representative of the Consumer Federation of America, also the Advocates for Highway and Auto Safety, the Center for Auto Safety, Consumers Union, which is the policy and research arm of Consumer Reports, and Public Citizen. And we particularly appreciate the invitation to be here today. What I'd like the committee to consider is any one of these experiences. You back into a pole, you sideswipe your car, you suddenly have someone stop in front of you and you hit them. Hopefully, this will not result in injuries. What it will result in is thousands of dollars of costs in terms of repairing your car. Why do these fender benders cost so much? One reason is because the parts are so expensive. Ford charges the same amount for a fender as Dell charges for a computer and a flat-screen TV. You can get a two-door refrigerator from Sears for the same price as a grill from Toyota. And guess what? That two-door refrigerator, those doors are already painted and installed. You'd have to pay someone to install the part on your car. And what's really significant is that these products, because of competition, have not only improved in quality, but they've also been reduced in price. Remember that in the early 1990s, the car companies came to you and asked for special design copyright protection on these replacement parts, and you emphatically said no. They've ignored your admonition, and there has been an enormous spike in the number of design patents by companies like Honda, Toyota, and Ford. Now, unless there's something special about a fender on a Ford for 2009 that wasn't special on that same Ford in 2002, I think you would agree that this is not some newfound design patent protection issue, but a newfound business strategy. For Ford, Honda, and Toyota and GM to come before you today and say that suddenly these parts are patentable, when for years and years they were not, is at the very least disingenuous and at the most extraordinarily costly for the American consumer. This is a business strategy, not a legitimate use of our important U.S. patent laws. The competition these car companies are trying to kill lowers prices, provides choice, and improves quality. If the automakers succeed in using design patents to eliminate competition, it will not only result in higher repair costs, but higher auto insurance premiums. On the safety side, not only was Congresswoman Lofgren correct in our concern about consumers not repairing parts of the car because they are so expensive, but let's talk about the safety of the parts themselves. I'd like to refer to the very organization mentioned in one of the testimonies submitted by the car companies from the Insurance Institute for Highway Safety. IIHS did address the issue of safety and determined that both in low-speed damage tests and high-speed safety crash tests, that alternative parts, CAPA certified to be the same, in fact performed nearly identically. And I would like to submit for the record a copy of the IIHS status report which describes these findings. The most tragic irony of the lack of competition is what I call the automaker's double whammy. Not only can they charge whatever they want for the parts we need to fix our cars, but when they charge so much that the car is totaled, our only recourse is to go back to them and buy another one of their products. The bottom line is that if automakers succeed in eliminating competition, the cost to consumers will be enormous. We applaud Representative Issa and Lofgren for introducing 3889. It is important to note that this is not a perfect solution. Representative Lofgren, as she mentioned, 2 years ago proposed a truly elegant solution. Allow the car companies to patent their parts and keep their designs from being copied by other car companies, but allow the independent production of those parts when used solely to repair a car. At that time, powerful car company and manufacturing lobbyists crushed her efforts to protect consumers. In the face of this intense lobbying to protect the use of design patents to prevent competition, H.R. 3889 represents a compromise. It is a step forward in helping us prevent us from being forced to pay unfair prices for the cars we need. Probably the most telling testimony submitted by the car companies was their suggestion that when one headlight or taillight gets damaged, consumers should be encouraged to buy both. Of course the car companies want us to replace perfectly good parts with their replacements. They would make millions. This is also why they are using the patent laws to thwart competition. Everyone is entitled to make a fair profit, but the car companies suggesting that we replace perfectly good and very expensive parts is way over the top. So CFA, the Advocates for Highway and Auto Safety, the Center for Auto Safety, Consumers Union, and Public Citizen believe that consumers need competitive crash parts. On behalf of these groups, I strongly urge Congress to adopt a repair clause to the design patent laws in order to ensure a competitive market with fairly priced alternatives to expensive car company brand parts. Thank you very much, Mr. Chairman.
Thank you, Mr. Gillis. I'll recognize myself to begin the questions, and my first question I'll direct to all three of you. 9 European countries and Australia, as has been noted by the gentlewoman from California, exempt crash parts from design law infringement. Have these laws worked well or not? Mr. Menifee?
From our understanding, they have worked well in terms of allowing the competition for aftermarket parts to function in an appropriate fashion as outlined in what this bill would provide.
Thank you. Ms. Burris?
I think you'll find in my written statement that I did obtain a report from one of my associates in Australia. A study was conducted shortly, albeit shortly after the enactment of that law, that found that it had no impact on the premiums, on the insurance premiums. So I think in that case, it was really too early to tell. I don't know if there's any more recent report, but I would encourage us to keep our eye on what's happening over there. I've also found out that in Europe, although the current law in the European community design itself is that you cannot get a design patent on a repair part, they are currently discussing that issue and trying to decide what parts and for how long they can have protection. So the European community is looking at that. Each individual country has its own laws, but when you get a European registration, there is one law that applies to all of those. And there are many countries that do allow design protection just like we do. Thank you.
Mr. Gillis?
Mr. Chairman, as I said in my comments, this is an elegant solution to the problem. It's fair, it's reasonable, and not only that, it has done nothing to...
Tell us about what you know about what's going on in these other countries.
Okay, what's going on in the other countries is basically the manufacturer of an independent part is allowed to produce that part, even if there is a design patent on it, if that part is only being used to repair the car. In other words, you cannot make a whole bunch of these parts and replicate the vehicle. But if a consumer wants to buy an alternative part, then that gives the consumer
I got you.
the choice.
Okay, let me ask Ms. Burris a question. You expressed a concern about the precedent that we might be taking here with regard to patent law, and I certainly respect that concern. But I also see a trend here. Why is it that for decades, car manufacturers, for the most part, did not try to use design patents to patent these parts, and this very competitive marketplace in crash repair has developed? What is the reason for that trend?
I think there are a number...
That trend concerns me as well.
Yeah, I've seen the trend myself. And I think part of the reason, or I think there are a number of things that contribute to that. I think one of them is the car companies had realized that their parts were being copied. When you sit down with your client and you have a new product that's being launched, you get in a committee and you sit down and you go, okay, what's patentable, what's not, what do we want to protect? And one of the questions that you always ask is, okay, which parts are replacement parts that someone's going to try to copy on our design? And you decide then, okay, these are the parts that we're going to...
But this isn't new.
I understand
People have been
that.
backing their cars into poles or colliding with somebody else on the highway for 100 years, and companies have been engaged in manufacturing parts that will fit to replace that when the vehicle is damaged that are not the manufacturer of the original part for a long time. I don't know how far back it goes. And yet now we seem to have a trend, and I understand that not all car manufacturers are doing this. Some are and some aren't. Some are doing it more than others. So I'd really like to have an explanation other than protectionism, if you will,
sure.
Why this trend is occurring.
Okay, there are a couple more things for you to consider. Okay, first of all, the copying of the designs has become more widespread, and it's very easy to copy a design now versus about 10 years ago. There are digital scanners you're probably familiar with. There are a lot of ways to do it with lasers, optical sensors that you can run along, literally photocopy a part, feed that digital information into your computer design system, into your CAD tube. That information then gets directly sent to the manufacturing equipment, and voila, a mold is made within literally a day of scanning that part. So the technology now makes it very easy to copy these parts. I think.
Are you saying that this is a new industry that's developed because of the ease with which you can copy the parts? Or is this an industry, the aftermarket parts industry that has existed for a long time, has established a place in the market, and they are feeling threatened by this new trend to patent to use design patents to exclude them from the market.
Yeah, my understanding from discussions with the folks at GM and at Ford, albeit limited, and I'm happy to go back and talk to the other manufacturers as well, is that they're chasing a problem. They're chasing people, pulling their parts, digitally scanning them, and then copying them.
Well, obviously, they've been copying them for years. If you're going to make a part, you've got to fit it on the car that was damaged, and so they had to make something that was a close facsimile of what was originally damaged, and I don't believe this is new. Mr. Menifee, can you tell us from your experience in paying for these repairs? Is this a new trend that we're seeing a more vibrant aftermarket industry, or has the industry been operating for a long time, making parts for almost any vehicle that's damaged?
Mr. Chairman, the aftermarket parts industry has been active for a number of years, decades, as you mentioned, and we've been utilizing aftermarket parts in terms of repairs through the insurance industry for that period of time. And I certainly have no specific knowledge of significant change other than development of technology, which applies to all manufacturers, whether it's the car manufacturers themselves or aftermarket suppliers. Certainly the nature of manufacturing has changed considerably in recent years. So there may be a factor there that, in fact, makes them more efficient. I also think the statement suggests that the quality of those parts is quite good because of the development of that technology. Then, in terms of, I would say today, our ability to buy aftermarket parts that are high quality and meet the test of like, kind, and quality and form, fit, and function is probably better today than it has ever been.
Is that a relatively new development, or is it something that's been evolving over a long period of time?
It's certainly been evolving over a good number of years.
Mr. Gillis?
Mr. Chairman, these parts have been in the market for at least 40 years. They've been very successful, not as successful as we'd like to see them, because still today the car companies have a monopoly on about 70% of the parts that we need to get our cars repaired. But they've been around for a long, long time, and it is clear that as the car companies make less and less money selling cars, they need to find other places to get their income from, and they're getting it from these parts. As I said, imagine paying $400 for a simple piece of stamped sheet metal. That's outrageous. There are headlights that cost $1,500. There are bumpers that cost $900. Why? Because there is no competition. And that's hurting us as consumers.
Ms. Burris, I'll give you an opportunity to respond to both of your critics there if you'd like, and then my time's expired.
Yeah, I think that the other point I wanted to make earlier was that I think that part of that uptick that you see is, and I think we've all recognized that automotive design, especially in recent years, has really taken off. I mean, there were some outstanding designs coming out of not just the big three in Detroit, but out of Honda and Toyota. I mean, the outward appearance of a car. I mean, look at the Ford Flex, for example, and the Toyota Prius. I mean, there's been, we're away from, I won't say K, I can't say, I'm going to do it. Chrysler's not here. Away from the day of the K car. There's been this.
No, but we're also well away from those big.
Where's the 57 Chevy when you need it?
That's what I was looking for, those big fins on the backs of cars. But I take your point.
But regarding the cost of the parts, I think that, being an engineer, I know what it takes to design these parts, and I know what it takes to do the materials testing and to survive. I think the refrigerator and computer example is really not fair. Those are not designed to be outside in 120-degree temperatures, in the ice and in the snow and not rust. They're not designed to hit a wall at 65 miles an hour without the condiments flying out either. That's an unfair comparison.
But think of all those magnets that people attach to them. So. Gentleman from North Carolina, Mr. Watts, recognized for 5 minutes.
Thank you, Mr. Chairman. I'm not taking sides on the question you asked, but the comments I've gotten from a number of people is that these suits picked up when foreign manufacturers of afterparts, mostly in Taiwan, started copying the components verbatim. And anyway, I'm not on one side or the other of this. I'm just trying to figure out where I should come down. Mr. Chairman, I ask unanimous consent to submit for the record a letter that's addressed to me and you, dated today's date, from Alliance of Automobile Manufacturers and various and sundry other organizations that they would like to have put in the record.
Without objection, it will be made a part of the record.
Okay. Mr. Gillis, Mr. Menifee, well, all of you, let me first say, I think all of you have made exceptionally good witnesses, and this is a difficult issue, it seems to me. Usually I know where I'm leaning, and I don't know where I'm leaning here. I mean, my sympathies are with the consumer, but let me put myself in the position of the consumer. I buy a new car. I drive it off the lot, and somebody bashes it a block from the dealership. Why shouldn't I be able to get my insurance company or anybody to replace that automobile with an original part from the manufacturer? I understand the cost considerations, and I am the owner, but I want my car to look and be up to the specifications just like I bought it. Why is that not a reasonable request? And why is it a legitimate argument counter to that to say, well, somebody else can make the same part when somebody has a design patent on that part? Those two questions, I guess, are the opposite sides of the same coin. Am I missing something here? Mr. Menifee, Mr. Gillis, you can address it from the insurance company side. I know the insurance company would like for me to go and buy the cheapest part available. It reduces their cost, but am I not, as a consumer, as a customer, entitled to have my brand new motorcycle be a brand new motorcycle? Or what do you say about that?
Yes, sir. Congressman, several questions there. I'll try to answer each of them as I go. Your first question, in terms of what do we owe to you as an insurance customer under most of our contracts, we owe you.
I got you. Okay.
We owe you a return.
You owe me something that appears to be the same.
Yes, sir. But that's what our contract says, and then we charge accordingly.
Okay. All right, but that's under the contract. Maybe Mr. Gillis is in a better position to argue this because he doesn't have a financial interest in it. Insurance companies always have a financial
Congressman, if I could just follow up to say our financial interest is our consumer. They are our customer, and ultimately our...
But if your customer wants an identical car to the one he just drove off the lot, in your customer's interest in conflict with your financial interest?
No, sir. Our interest and our customers' interest are very much aligned. We want our customer to be safe and happy, and in that case, we think the contract provides for that. The contract says we can... Go
ahead, Mr. Gillis.
Well, first of all, Representative Watt, we don't really see this exactly as an insurance issue. It is much more of a consumer issue from the perspective of giving me the right.
That's why I put myself in the consumer's position.
Right, the consumer. For example, you drive down the street and you decide you need a new muffler. Well, you can go to Chrysler and pay $900 for that muffler, or you can go to Midas and get one for $189. That's a great choice. Now, if you really want that Chrysler muffler and you want to pay $900, you've got that choice. With a fender, it's the same thing. You may not want to pay $400 for a fender. You may want an alternative choice that's maybe a third the price. And all we're saying is let's let that choice exist. Let's give me that choice. Now, if I want to buy an insurance policy...
Even if somebody's got a patent on it, you're saying, I mean, you know, we could extend that, that analysis to just about any product.
Well, we have a great deal of respect for patent law. That patent law is very, very important, but it's not being used in a legitimate fashion. As Chairman Goodlatte said, why all of a sudden are
okay,
these
but you say legitimate fashion. Is it legitimate for somebody to scan my patented part and reproduce it the very next day? I mean, we don't allow that under our patent laws.
Right now, that would be illegal, and that's what we hope this piece of legislation would allow. So solely for the purposes of not...
So you want to facilitate somebody being able to scan that part and produce it the very next day after it's driven off the lot?
Solely for the purposes of making a repairable part choice available to me, but not for the purposes of allowing General Motors to copy Ford's design or Ford to copy Honda's design.
So if you're not an automobile dealer, you can copy somebody's design, but if you're Ford or General Motors, you can't copy each other's design.
That's right. If you were copying these parts to reproduce the General Motors car, that should be, and we respect the fact that that should not be allowed. But if the sole purpose is to give me a choice as a consumer, to have some choices in the market, like I do at a drugstore when I can choose, you know, CVS brand aspirin, or like I do in a repair shop where I can get a Die-Hard battery.
But you can't go into a drugstore and buy a CVS brand aspirin while somebody else has the patent on that aspirin.
Right, and we could
you know,
have
there's limits to this.
Well, we could have a whole hearing on the drug company's use of patents and potential abuse of patents. But the bottom line is, Representative Watt, car companies really need to acknowledge the fact that, as the chairman said, why are they suddenly doing this? Why is this part patented today? You know, the representative from the car company said, you know, there are outstanding designs on the market today. Well, those parts have been around for 40 years, and they're not preventing outstanding designs.
All right, I guess hearings have very important purposes. They either clarify the situation or they confuse you more. And this one, this one has left me extremely confused. I have to, I mean, you know, because it's very difficult to know which side of this issue to be on. I understand exactly what you're saying, but as the intellectual property subcommittee person, I don't know how exactly we put this into our current framework. And the fact that somebody made a high-quality knockoff, it doesn't seem to me to be a sufficient justification for allowing them to market that knockoff if it is a patented item. You know, that's what I'm having trouble with. Mr. Chairman, I'm sure we'll debate this and hear a lot more about it, so I'll yield back my time.
I thank the gentleman. The gentleman from Nevada, Mr. Amade, is recognized for 5 minutes.
Thanks, Mr. Chairman. In the testimony here, we've heard talk about crash parts. What % of the market is crash parts? I'm assuming we're talking about new vehicles here, which means there's not a lot of folks restoring them. So I'm guessing if I have a 3-year-old vehicle and I need a new fender, it's because it's subject to a crash. Anybody want to tell me what % of the market is crash parts? Exterior only? Nobody wants to?
Congressman, industry data that we have would suggest 15 to 20% of the collision repair parts come through the aftermarket at the present time.
No, I mean crash parts generally. We'd heard a talk about an elegant solution from Mr. Gillis that would say crash parts only. I'm assuming that's a large chunk of the market if it was crash parts only.
Well, there are two types of parts on the market. There are what we call...
I understand that. Well, the question is, what percentage? If you know, it's okay to say you don't.
It's about a $16 billion
Okay.
market.
So we don't know what percent of the market we're talking about. That's something, if somebody can get that later on, I'd appreciate it.
Sure.
Second, Ms. Burris, sorry, I probably shouldn't be driving. Mr. Menifee indicated that when somebody buys a car from one of your clients, that they've been compensated for all their R&D, all that other sort of stuff that you kind of intimated. What's your response to that? Does the manufacturer have any interest in any R&D after I pay $35,000 to whatever company for my car?
Yeah, I don't think that they've been fully compensated for their R&D when they sell that car.
Well, if they haven't been, then would this bill encourage them to increase the price so they are getting? I mean, if you no longer have a back end on the parts, I would assume that everybody's going to be affected equally in the manufacturing process and that they're going to increase the price of their cars if they don't get something on the parts. Is that, is that a bogus statement, or how do you get compensated for R&D generally?
Yeah, if it's okay, I would like to go back to the GM and Chrysler and Ford and ask them. I can get that information back.
That'd be great.
I'm the patent attorney. I don't work at the automotive companies.
Okay.
But I'd be happy to get that information and put it back in the record.
That's fine. Mr. Menifee, if this bill passes, are auto premiums going down for all those, for all of Mr. Gillis's consumers?
Well, I think the position we've laid out is a concern about premiums going up.
So is the answer to my question no?
I would not expect premiums to go down. As a result, we are preserving the competitive environment we've historically had, which I think would suggest that premiums would, in terms of the result here, would be to keep that part of the premium relatively the same as compared to going.
Mr. Gillis, how's that work for consumers? Is that a good answer for your consumers? Auto insurance premiums?
It's not a great answer, no.
Okay. Thank you. I appreciate that.
But let me just say this. There are choices that consumers can make both in terms of parts and in terms of auto premiums. Some consumers actually choose insurance premiums that give them only car company brand parts. Now, those tend to be more expensive.
Yep.
But those consumers are willing to pay that. Most consumers are shopping around for the least expensive insurance they can get, and this is one of the ways that insurance companies can reduce costs.
Yeah, and I appreciate that. Finally, there was testimony about launch period, best guess, some relief for consumers. If I might, I think it was you, Mr. Menifee, that talked about launch period and best guess. Can you put a little more meat on that framework in terms of why 30 months works as opposed to 14 years or no period?
Well, I think the evolution of the bill as proposed has resulted in that 30-month number being a relative compromise. That's reasonable. All parties concerned, at least in terms of the discussion and debate so far. I'm sure you could argue on either side of whether that's not. And I'd also make the comment it's not inconsistent with at least what our company's practice has been, is generally to use OEM parts during the first 2 years that a new vehicle is owned by the consumer. And I think all things considered, the 30-month is a reasonable compromise.
Well, and I appreciate that. But to tell you why I asked the question, because I get the consumer part and I get the cost of insurance, and I also get the R&D part. So what I'm looking for, and it's like, well, good luck finding that because you're the only one looking for it, maybe is what is the investment in R&D? What's reasonable how to treat that in the context of providing consumers choice and also keeping their insurance premiums as low as possible. So when I hear terms like best guess or launch period, it's like, well, okay, what's the basis of that statement? And I'm sure there is some, so if anybody can follow that up later on, that'd be great. With that, I want to thank the panel for your candor and yield back, Mr. Chairman.
I thank the gentleman. The gentlewoman from California is recognized for 5 minutes. Ms. Lofgren.
Thank you, Mr. Chairman. I'm sorry that Mr. Watt had to leave, although I certainly respect that all of us have many things to do at once, so I'm not critical of that. But I think it's important to go back to the Constitution, as Congressman Issa has, and to reflect on what the Congress is asked to do. We are asked to promote the progress of science and the useful arts by securing for limited times the exclusive right. Now, when the Constitution was adopted, the Congress chose 14 years as a patent term. It's entirely up to us to decide what is the appropriate time of protection to promote the useful arts. And that is not in any way adverse to our obligations or even our history as a country. And I just think it's important to reiterate that point. Now, in terms of safety, there's been some concern expressed by Ms. Burris that parts that were not provided by the original manufacturer would be less safe. Mr. Menefee, you are actually, as I understand it, a member of the board of the Insurance Institute for Highway Safety. I think, isn't that the group that gave us the crash dummies? Can you address the issue of safety directly as to these non-original manufacturing parts? How can we know that they would be safe?
Yes, ma'am. Congresswoman, first of all, I'm an engineer. I started out my career in heavy manufacturing, doing product design and product manufacturing. I have a good appreciation for what's involved with that. I also have a good appreciation for what's related to being able to do that and manufacture parts that are of high quality and meet the standards that they need to meet. And as a board member of the Insurance Institute for Highway Safety, I have been around these questions of quality a lot. This is not a new issue. The Insurance Institute has addressed it over, I believe, the past decade or more in terms of the question, do aftermarket parts meet the test when it comes to quality and safety. The IHS has conducted tests and concluded that the source of a car's cosmetic car parts is irrelevant to crashworthiness and safety. And I would make the distinction there in terms of those are the cosmetic parts as compared to the structural parts. And in fact, there's very substantial information. The issue has been well vetted that safety with aftermarket parts is not an issue. It's just that's, I think, very well established.
Now, I'm interested in, we all are impacted by our own personal experience, so I'll tell a story on my daughter who came out a couple of years ago and borrowed my car and unfortunately had a small accident with my car. And it didn't look that badly damaged, but the insurance company said, no, just total it because it'll cost more to fix it than it's worth. And I'm just sort of replicating that because it was totally fixable, and I would be happy to have had it fixed. I didn't want to go out and buy a new car. I'm interested in the impact that something like this bill might have on the number of vehicles that are simply totaled that could otherwise be repaired and are totally usable. Do you have any idea what that might be, Mr. Menefee?
I would not hazard a guess as to exactly what the percentage would be, but certainly it would have an impact. In most cases, auto insurers look at damages approaching 75 to 80% as being something that we would consider a total loss, and then replace the vehicle or settle up with you to replace the vehicle as compared to trying to repair it. Certainly, the elimination or diminution of aftermarket auto parts would raise the repair cost, which then would suggest a higher percentage of vehicles being put into that category. That's a concern, and just generally, that's a concern not just for insured customers, but for non-insured customers as well, of which there are many who have to pay for those repairs out of their pocket as compared to relying on the insurer to do so.
Well, I certainly understand that this is a new concept for some. To me, certainly we want to make sure that we have a vibrant and successful auto industry sector in this country. I voted, and I was happy to vote on the so-called auto bailout, and I was glad that the auto companies came through and they're on their feet and they're competing. It's great. But right now, when a consumer goes out and buys a car, they're not just buying a car, they're buying indentured servitude to the manufacturer for the life of the car. And most people don't realize that. I mean, if you're buying the design and the performance and everything else, but if the patent term is 19 years and the car usually lasts 10, I mean, you really are stuck in a way that most consumers do not intend. And my belief is that the competition that the auto companies have is performance and design among other new vehicles. It's not to get their claws into the consumer if they have an accident 15 years later. And I think Mr. Issa's bill helps create the competition that will save money, preserve safety, and I think also help create a more vibrant aftermarket industry in the United States. And with that, I would yield back, Mr. Chairman.
Time of the gentlewoman has expired, and the gentleman from California, Mr. Issa, is recognized for 5 minutes.
Thank you, Mr. Chairman. Ms. Burris, you said a few things that I think I'll, no surprise, might take a little exception to. Now, you're a patent attorney, so the quality of these parts, the NRE, the non-recurring expenses, those aren't areas of your expertise, are they?
For my expertise, no. As a consumer of my concern, yes.
Oh, so you, as a consumer, you would ask how it is that the auto companies can make 1 million Toyota Camrys on a die, and then when they have to make 1,000,001 to sell it as an aftermarket part, they can't compete with somebody who had to make a brand new die just to make aftermarket parts. Isn't it true that from a standpoint of cost, the tooling cost to just make aftermarket parts actually puts the repair parts person behind, not in front? Well, let me rephrase that. I already said you don't know about the cost of these things. So let's go on to something else. You know about patent law. Okay. Do I own the patented product when I buy it? Do I own that fender, that front right fender on my Lexus?
Absolutely. Subject to any terms and conditions of the purchase of a patented product, you own that patented product. You can repair it. You can. Okay.
Well, the patent law is the patent law. The terms and conditions don't modify the patent law. You can't add to the patent law by having an implied contract. I know people have tried to do it. So let's go through this a little bit. Your Mr. Gillis's car, his Lexus, gets ruined, but the front right fender is okay, and it's in a junkyard. Is it okay for me to take it off that and put it on my car? That patent survived. His patented front right fender survived the crash, right? So I could buy that. Okay, for sale doctrine, right? It's the patent transfers. He can sell it. I can buy it. I put it on my car. Okay, and I can take that fender that got crunched and I can bend it back out and I can make it exactly the same as it was, and I haven't violated the patent because I own that, right? Okay, now if I simply fabricate a fender myself to do the job that the first fender did I violate the patent law?
Yes.
Oh, okay. So you're saying that, in fact, even though I have this fender that I'm going to scrap, I don't have the ability to duplicate a replacement part.
You don't, but the practical matter is the car company's not concerned with the mom and pop shops.
Right, they're just concerned about making this profit by having this exclusive. So let's go through this. I own this right, and you're telling me, and Mr. Watt, if he were still here, maybe this would make him less confused. I own this right, I own this part, but if the part's dinged, I can cut out the dinged part and I can weld in a new part. I can unbend it. I can move it back into the shape it was. That's all okay. I can take 80%, 50%, 60%, 90% of the metal, cut it away, and weld in new metal. I'm okay, right? Can I take 99% and weld and just take the little spot where the screw fit into the part and the rest of it, and can I fabricate it back onto that one part?
Sure you can. Okay.
So what you're really saying is this is about the money the auto companies want by having an exclusive, and that's all well and good, but what they're really saying is even though I bought and paid for this part, they don't want me to do it. Well, let's go through this whole point. I'm trying to make a form, fit, and function replacement part from scratch. The design patent is limited to ornamental, correct?
Correct.
So I'm entitled to make a part which has form, fit, and function perfectly, and I haven't violated the patent because the patent is limited to ornamental, right?
Yeah, design patent covers the ornamental features of the part, correct?
Okay. So what you're saying is the ornamental feature is the only part that I'm taking. So it's a crease, it's a line, it's something of no value for form, fit, and function, right?
I'm not sure I followed you. It's the overall design that's protected. It's not one
No, it's not the
feature.
overall design. A design patent on a particular fender is limited to its ornamental value. It can't be form, fit, or function, otherwise that'd be a utility patent, right?
That's correct, in terms of its coverage.
Okay. So, Mr. McAfee, you mentioned something I think that was a little confusing before, and I want to make sure I get it clear. The reason you said that it wouldn't necessarily result in lower cost is because so far this practice of patenting and suing and stopping the importation or manufacture of parts is not widespread. Isn't that true?
Yes, sir.
So it's actually something that didn't go on for the first 100+ year of the auto manufacturing business that's beginning to go on, that is driving up the price of these and making aftermarket products not available.
That's correct. Our concern is at the current time and on a prospective basis.
Okay. Well, quickly, I'd like to ask the unanimous consent that the Coalition for Auto Repair Equity, the CARE, statement of July 27, 2012 be placed in the record.
Without objection, so ordered.
And I'd like to just note for the record, for those who may not go back quite as far as an old guy like me does, that Carol Shelby, born died May 10th of 2012, was born in 1923. Roy Wachowski, who was a friend and a customer of mine, was born in 1915, died in 1997. In the 1970s, early 70s, I was buying from a well-established J.C. Whitney catalog repair parts for Kaiser Willys and for so many parts, particularly from automobile companies who did not keep their commitments, who were no longer making these parts, including Volkswagen of America that would not make parts. This industry has been well established for my entire life, and I think the important part is that, in fact, we are talking about a narrow bill to prevent a new expansion that endangers the consumer's ability to afford repair parts, and I yield back.
Gentleman's time has expired. The gentleman from Texas, Mr. Poe, is recognized for 5 minutes.
Thank you, Mr. Chairman. I am one who actually has been a customer of a junkyard. I'm not sure you have ever been to a junkyard, Mr. Issa, but maybe you have been. If you have, that's great. But
I will show you the picture of my 1963 VW bus, and it is all junkyard parts, my friend.
So I frequent the place in Southeast Texas for several reasons. I don't know that on my 98 Wrangler I have an original part on it. And many of them have come from replacement parts that have been found at a junkyard. So, but be that as it may, I'd like to start with the insurance first. Having been dropped by most insurance companies in Texas at least once over the years, driving that 98 Jeep Wrangler with the 6-inch lift. I want to ask you some questions. They set a price. The manufacturer sets a price on a bumper. First of all, I'd like to ask the lady from that represents the manufacturers, why do these bumpers or parts cost so much? Mr. Gillis says his folks can sell them for 1/3 of the price and still make a profit. You sell them for, 3 times that, and I mean, why are they so much?
Well,
Are you gouging the consumers?
are they really that much? I mean, I think that it's a relative look. I mean, once someone comes along and copies a part, they don't have to do any R&D.
No, just answer my question.
No,
I don't want, wait a minute.
I don't know that they are.
Just a minute. I reclaim my time. First of all, the original manufacturer part is more, generally, is it not, than the replacement part that his guys sell?
Yes.
Okay. Why is it so expensive? Rather than like the lady from California, Ms. Lofgren said, let's replace the part. Insurance guy says, hey, that's too much money. We'll just get you a new car. Why are the parts seem to be so expensive from the manufacturer? That's my question.
Yeah, it's a valid question. I think in a lot of cases, the parts that you're buying from the original equipment manufacturer are higher quality. They're better materials. They're going to last longer. I asked my students this question in class last week. I showed them the bill. I didn't tell them, how I felt about it. How do you guys feel about this? And one of the students said, well, he goes, I just put a new bumper on my F-150. He goes, and within a year, he goes, it rusted. And I went back and said, hey, why is it rusting? And I found out it's a non-OEM part. Now I know to ask for OEM parts. Now, I'm not saying that's the case every single time. There may be a part that has the same materials, same structural characteristics, but I think there's a concern that these parts, if we're going to do this, you want to make sure those parts are the same parts. They have the same materials, the same durability out in the environment, the same structural integrity.
Excuse me, I just have a little bit of time. Mr. Gillis says it's generally the same part. We're not talking about a part that's not the same part. We're talking about a part that's made an aftermarket part. It's the same general part, made out of the same material, maybe made in Taiwan instead of Pittsburgh, but
I have experience. I'm a Jeep person myself. I was like, hey, you're my kind of guy. I have a Jeep, and the front radiator had to be repaired. I didn't know it was a non-OEM part. Paint chipped off of that thing in 2 weeks. It looked like crap. I went, hey, what's wrong with this radiator? Well, it was cheaper. We got you the cheaper part.
all right. Do manufacturers, you have your patent law over a set number of years. How long do you keep parts? So I got a new Jeep. Let's say I bought a new Jeep, which would not happen, but let's say I bought a new one. How long does Jeep keep the parts for that vehicle?
I personally don't know that, and I would have to go back and ask.
Toyota or GM, do you know any of them?
I don't, but I'm happy to gather that from.
A long time ago they had to keep parts for 20 years. Yeah. And that was done away with by Congress, I understand. But so there's no requirement that you keep a stock of parts for a certain
I'm sure each
vehicle.
Manufacturer has some kind of guidelines they use, and I'm happy to go gather that information and bring it back. But I don't know that right now.
All right. And Mr. Miffy, on the insurance angle, people can buy any kind of insurance they want. They can get replacement parts that come from the manufacturer. They can get the insurance that just says it's a replacement part. It doesn't have to come from the manufacturer. People can do that, though, through their insurance that they buy. Is that correct?
There is some flexibility, Congressman. However, we are a highly regulated industry, so the policy provisions are pretty much dictated by the state insurance departments in terms of what we do or do not offer in that regard. And in fact, in most states, the requirement is the repairs are like, kind, and quality, form, fit, and function, and that's what we honor.
So if I showed up with the Jeep and wanted to get repaired, I would be allowed to get a part that is equal to the original part on that vehicle.
Yes, sir. And in fact, in our experience, we're very careful, and I think the industry, this is typically the case. We're required to disclose to the customer what type of parts are being used to repair that vehicle. And we do get questions sometimes about OEM versus aftermarket parts. And as soon as we understand we explain the manufacturing and quality control process that most of us in the business use to control those aftermarket parts, the customer is very satisfied, and in fact is usually focused on cost effectiveness, that they want a good repair at a fair price.
Last question, if I may, Mr. Chairman.
Objection. The gentleman is recognized for 1 additional minute.
Safety. I'd like to hear what you all three think about aftermarket parts, not the junkyard parts, but aftermarket parts and original parts, whether generally if you get the same part, it's going to be just as safe or not. Just each one of your answers. It either is or it is not in your opinion. Mr. Menifee, start with insurance.
If the aftermarket part has been manufactured and under the quality control and certification conditions that we would say it should be, there is no doubt in my mind, in terms of my background as an engineer and my experience with the Insurance Institute, that aftermarket parts are equally safe and equivalent to original equipment parts.
Ms. Burris?
As an engineer as well, I would agree with that if they're designed to the same specifications, the same materials, that they're going to have the same safety, same quality. It's not just on a part basis alone, though. Those parts interact with one another. It's a vehicle system. So one part triggers a reaction in another part, so it's not just the part itself, it's how it interacts with the parts around it. So, but, if it's designed to the same spec, sure, it's going to perform the same.
Gillis?
There are programs available that actually confirm the fact that these parts are virtually identical, and many insurance companies take advantage of those programs to protect consumers from two things: poor quality parts and overpriced parts. Okay. The real question is the quality of car company brand parts. That's something that the committee may also want to look at, because let's face it, in 2010 there were more cars recalled by the car companies for quality and safety problems than there were even sold. So they don't have a lock on quality, and it's important to remember, let's not use that as an excuse not to use competitive parts.
And Ms. Burroughs, if you would get the committee that information regarding how long generally a manufacturer keeps in stock or available parts for a specific model. Appreciate that. I yield back.
I thank the gentleman. The gentleman from North Carolina, Mr. Coble, is recognized for 5 minutes.
Thank you, Mr. Chairman. I was here earlier and had to get to another meeting. Mr. Menifee, if this bill is enacted, would it result in a reduction of insurance premium rates? And if so, when would the consumer embrace that or be aware of it?
No, sir, Congressman. We have taken a position and communicated that the intention here is to preserve the competition that currently exists in the marketplace, so that we are working to pass the bill to avoid a significant increase in the cost of parts and insurance premium.
Well, would there conversely be a reduction in premium rates?
Our expectation is if the bill is passed, we will maintain the current competitive environment we have, and as a result, there would be no appreciable change in insurance premiums.
Anybody else want to weigh in on that?
Well, I think that's a good point, Representative. I think the issue here is insurance premiums are based on what's in the market now. If the car companies are successful in keeping that competition out of the marketplace, it's inevitable that if an insurance company has to buy $400 parts to repair a car, they're going to charge me more for that insurance.
Thank you, sir. Ms. Burris, in your testimony, you alluded to motorcycles and other types of motor vehicles. Elaborate on that again for me.
Sure. The language of the bill calls for component parts used in motor vehicles. And under our Title 49, the definition of motor vehicles says, any vehicle that is driven or drawn by mechanical power manufactured for use on our public streets, roads, and highways. So that's more than automobiles. That's a whole lot. I mean, it's motorcycles, it's mopeds, motor scooters, farming equipment, trailers. It's not just driven by, it's drawn by.
Lawn mowers, maybe.
If it's for use on public streets and roads and highways, plows, it's wider and broader than just automobiles.
All right, thank you. Thank you all for being with us. Thank you, Mr. Chairman.
I thank the gentleman. I want to thank all the members of the panel for a very, I'm sorry. We now have 2 new members who've arrived, so we're going to continue on, and we'll next recognize the gentlewoman from California, Ms. Waters, for 5 minutes.
Thank you very much, Mr. Chairman. I'm sorry I was delayed and unable to be here, but I wanted very much to be here for a number of reasons. I appreciate the hearing today as an opportunity to hear from the various stakeholders regarding the Promoting Automotive Repair Trade and Sales Act. Indeed, this issue is of great importance to many of my constituents as it concerns the maintenance and repair of automobiles. The auto dealers contend that the legislation would unduly deprive them of their intellectual property rights, which would lead to revenue and job losses. Given the economic challenges that many auto dealers continue to face under declining sales and limited access to credit, the Parts Act would prove devastating to a single fragile industry. Indeed, the Parts Act raises a fundamental public policy question, as it would reduce auto companies' patent protections from 14 years to 30 months. The auto companies are also concerned about the quality of replacement crash parts. Let me ask this. One of the things I have focused on in looking at these challenges that continue to arise about these issues is what kind of investment and maintenance resources go into protection of the intellectual property rights that is being challenged. I don't know who that, Ms. Burris, let me just ask you.
Sure, I'd be happy to answer that.
Yes.
There's thousands and thousands of dollars spent on patent applications. There's the time that that the attorney spends preparing the specification, the claims, and in this case for design patents, the claim is the drawing. So there are professional drawings prepared to show the article of manufacture from a number of different views. You pay your filing fees with the USPTO. Design patents are a little unique in that once you pay your issue fee, when it's ready to be issued, you don't have to pay maintenance fees after that, just like the utility patents. So the investment per design patent for an applicant is on the order of, it's thousands of dollars, $3,000 to $4,000 per patent. And again, I think you weren't here earlier when we talked about this bill. The language of the bill is retroactive. So if you got your patent 5, 6, 7 years ago, and you paid all that money, you have nothing to show for it. And also the language of the bill, it's not 30 months from the issue date of the design patent. The current term for a design patent is 14 years from the issue date. The language of the bill does not say 30 months from the issue date. It says 30 months from the date of the offer for sale. So what happens, the reality is when we work with our clients, they're getting ready to go to a big auto show or to go see a customer. The design has been refined all the way up until that date. I've been there, done that, at 11 o'clock at night, changing designs right before launch. And so you file your patent application the night before you offer it for sale. Well, it takes over a year for you to get your patent through the patent office because of, it just takes a while to get it. There's a delay. It's over a year. So really, it's not 30 months of patent term. It's closer to a year or a year and a half at best of a patent term.
Well, Mr. Chairman, I thank you for allowing me a few minutes here, having come in late. I just have to say that I part with some of my consumer activist friends, and I'm known as a consumer person, but I'm old-fashioned in that I believe that if you discover and develop that you have a right to reap the benefits from it for a reasonable period of time, and you can always develop a better mousetrap, but don't take mine. So Mr. Gillis is trying to get my attention.
Congresswoman Waters, our
Yes.
dear friend.
Yes.
Think about what you just heard. It costs $3,000 to $4,000 to file a patent that allows the manufacturer to force me to pay $400 for a particular part for 14 years. All they have to do is sell 5 parts and they've covered the cost of their patent, as you just heard. And then they've protected themselves from me being able to go out into the marketplace and have a choice. That's what this is about. We need your help. We need you to stand up for consumers and support this effort.
Well, I don't want to repeat myself, but I stand firm in my belief. And it sounds a little bit unusual for me, but the fact of the matter is, whether you are a small company or a big company or an individual, if you are smart enough and if you are inventive enough to come up with something that you can patent, I want you to enjoy the benefits of it. And one good thing about it is, like I said, the next person can invent a better mousetrap, or they can go for whatever they can produce. But I just don't like the idea of investing in a patent and then all of a sudden it's not yours after a short period of time. It just doesn't seem right to me. So you can keep talking to me, Mr. Gillis, but that's where I am right now. Thank you.
I thank the gentlewoman. The gentlewoman from Texas, Ms. Jackson Lee, is recognized for 5 minutes.
Thank you very much, Mr. Chairman. I know that this bill has changed underlying bill, and hearing on the underlying bill had some changes to it. And I think, however, the basic premise is one that we should look at very, very closely. And I think all the witnesses will know that what you hear from many of your constituents is costing as it relates to fixing cars, whether they are a recent vintage or older vintage, and I assume it is partly because of that famous word, parts. So let me just start and go across the board and ask each And if you could have succinct answers, if you don't know, you don't know. And thank you all for being witnesses here today. Will the auto industry support this bill in any form? Could I start with Mr. Menifee and go on to Ms. Burris and then Mr. Gillis? Mr. Menifee?
I'm sorry, Congressman. So the question is?
Would the auto industry support this bill in any form if it would be modified? I know you are supporting the, opposing the premise, I guess, of dealing with parts and ignoring the patents and the design issues.
Well, my response there would be we respect intellectual property and patent rights. Clearly, we do believe that this bill strikes a compromise in terms of the protection that should be offered there and still affords consumers what they deserve in terms of competition in the aftermarket parts area in terms of collision repairs on their vehicles. So we support the bill because of that.
And if we modified it more with respect to concerns that will be raised by consumers, your view would be you'd have to look at it. If we did more for consumers.
Well, we think the bill does quite a bit for consumers as it's currently structured.
All right, Ms. Burris?
I'll give you a real succinct answer. I mean, that'd be a negative ghostwriter. We would not support this bill. The design patent laws provide for 14 years, and that's what we should have. So we do not support this bill in any form.
Appreciate that. And, of course, Mr. Gillis?
There's clearly way too much money at stake for the car companies for them to ever support the consumer-oriented bill that's before them today.
And why don't we pursue that a little bit more, Mr. Gillis, on this question of money and juxtaposed against what benefits come to the consumers because of the approach that we're looking at?
Well, there's two things. First and foremost, most of us are in pretty desperate financial condition. And I would like to set the record straight that Representative Issa called me a Lexus person. I've got 4 kids, so I'm more of a Hyundai person. And most of us are scrimping and saving as much as we possibly can. When it comes to backing into a pole and having it cost us $2,000 or $3,000 to get our car fixed, our fear is, one, consumers are simply not going to be able to afford to have that car fixed. It'll degrade the value of the car driving it around with an accident. And worse, maybe they won't replace some of the important safety features. So there's a lot of problems associated with the lack of competition and the fact that that lack of competition dramatically increases the cost of repair.
And I'm glad you mentioned a Hyundai or other import thereof. And the concept is that the $2,000 or $3,000 comes from buying the part that comes from or is allegedly necessary for that vehicle. And is that part made in the United States or overseas? And I know there's some plants here. And is there a question? There is a question of whether or not we are promoting domestic production by this legislation, or are we just furthering the move of manufacturing overseas?
I appreciate that question, and I'm glad you raised it because there is this constant undercurrent by the car companies that this is somehow trashing American business and hurting American production. I'd like to submit for the record the fact that 2 of the most popular built American cars, the Ford Focus 2012 and the Chevy Cruze, the 2011 version of the Cruze, 63% of the suppliers that Ford has chosen for the Ford Focus are foreign manufacturers. 50% of the suppliers that Chevy has chosen for the Chevy Cruze are foreign suppliers. So this isn't a foreign versus domestic issue. This is a fairness issue, and consumers have the right to choice in the marketplace, and that's what this bill will give them.
How would you answer Ms. Burr's question about the 14 years and her inability to support this legislation based on the patent design issue?
Well, quite frankly, we believe that this bill here is a compromise, and we originally supported Congresswoman Lofgren's very elegant solution because these patents are being used not to protect legitimate work or legitimate designs of individual small parts, but these patents, as you can see by their dramatic increase over the last 3 or 4 years, are being used as a competitive tool. It's great to have patents, it's great to have design protection, but it's really unfair to consumers if that's being used solely to protect markets. And that's why the Consumer Federation of America, Consumers Union, Public Citizen, the Advocates for Highway and Auto Safety, who are here today, are against this bill. Excuse me, for this bill, against the 14-year practice.
We've been there before. Mr. Chairman, I just want to put on the record one statement. I thank the ranking member, and that is to express my dismay, having helped bail out the auto industry about a year or two ago for a 50% utilization of foreign parts versus domestic parts, which could enhance the manufacturing sector in the United States. And I know that we're not the trade committee, but maybe we can begin to understand that more and enhance the legislation accordingly. With that, Mr. Chairman, I'd be happy to yield back.
Mr. Chairman.
I thank the gentleman. The gentleman from California.
Could I get unanimous consent for 30 seconds to just raise a question? And I'll talk with my husband about it a little bit tonight, but he tells me that the labor cost.
Without objection, the gentleman is recognized for 1 minute.
Thank you. That the labor cost in the repair of these automobiles is much higher than the parts. Is that true?
No, I don't think so. It's about a 50-50%. About 50% of the cost of the repair goes into labor, and about 50% of the cost of the repair goes into the parts.
Okay, I'm going to go back and check all of my repair bills.
Yes.
And compare the parts, the cost for the parts and the cost for the labor. Yield back the balance of my time.
I want to again thank all of the witnesses for their excellent testimony and for a very lively discussion. And before I adjourn the hearing, I want to recognize the gentleman from North Carolina for another unanimous consent.
I ask unanimous consent to put the letter of the Intellectual Property Owners Association dated July 31, 2012, addressed to me and you into the record.
Without objection, so ordered. And without objection, all members will have 5 legislative days to submit to the chair additional written questions for the witnesses, which we will forward and ask the witnesses to respond to as promptly as they can so that their answers may be made a part of the record. And without objection, all members will have 5 legislative days to submit any additional materials for inclusion in the record. With that, I thank the witnesses and declare this hearing to be adjourned.
What's the gist of it?